Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I am your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for nearly a decade. You can find me on all social apps at Joshua Ritter ESQ or at joshuaritter.com. We are recording this on Wednesday, June 11th, 2025. In this week's episode, the approaching conclusion of Karen Read's retrial as the final defense witness takes the stand. Plus, the latest in the federal sex trafficking case against Sean Diddy Combs. But first, breaking news as jurors have reached a split verdict in the case of disgraced Hollywood mogul Harvey Weinstein. Today, we are joined by Neama Rahmani, an attorney, author, and legal analyst you can catch on multiple news outlets. Neama, welcome back.
Thanks, Josh. Glad to be back. Big day today.
Yeah, big day today. How have you been, my friend?
Good. How about you?
Very good. Thank you so much for joining us. I always love watching you on whatever news outlet you're on because you have such a wealth of experience having come from the federal prosecutor's office. And I know that you are a very busy trial attorney. So I'm going to press upon that experience of yours today. But let's jump right in out of Manhattan, New York. After another harrowing trial, jurors have reached a split verdict in the retrial of disgraced Hollywood mogul Harvey Weinstein. In the landmark New York retrial, the jury found Weinstein guilty of one of the top charges while acquitting him of another. Ultimately, the group could not come to a consensus on the third charge. Through the heated deliberations, jurors convicted Weinstein of forcibly subjecting a victim, Miriam Haley, to a criminal sex act in 2006. However, jurors acquitted Weinstein on acts related to accuser Kaya Sokola, whose accusations were added to the case last year. As jurors considered the count of third-degree rape, the deliberations became so contentious that the jury foreperson asked the judge if he could be dismissed. The foreperson claimed that jurors were attempting to force others to change their minds, telling the judge, "I can't go back in there with the other jurors." The retrial had a starkly different outcome from Weinstein's initial trial 5 years ago, despite a woman majority jury stacks 7-5. Weinstein is still looking to overturn his California convictions, and we will keep you updated on any news on that front. Neama, what's your reaction? Do you think the defense walks away from this looking at this like a win?
I do. And look, obviously, the fact that we're even talking about this trial is a win for the defense, right? That case went up on appeal. The New York Court of Appeal, which is their version of the Supreme Court, said, hey, these prior bad acts witnesses that came into the first trial, that was unlawful. So now, Harvey Weinstein gets that second bite at the apple, but, we're going to be talking about Sean Diddy Combs, but there's a lot of similar arguments being made in both cases. And the argument is this: hey, if you were sexually assaulted, why did you continue having a relationship with your abuser, right? So that's what the defense argued here. And I'm not saying I necessarily believe it like you, Josh. I'm a former prosecutor, current plaintiff's lawyer, but that argument does resonate with a lot of jurors or members of the public. And I think the fact that they got a not guilty, they're likely going to get a mistrial, at least with respect to this third count, because if there's a potential physical altercation, one of the jurors is saying that someone told him, "I'm going to see you outside." I mean, I don't think the jury is returning a verdict of any sort on that count. So if you get a not guilty, you get a hung on 2 of the 3, that has to be a win for the defense.
That's a really excellent point. With as contentious as it sounds like it was for the jurors, especially with the foreperson saying, "Don't even send me back in there, Judge. I can't take it anymore." I know that the judge was talking to them about continuing to deliberate on that third count, the one that they had not come to a decision to. You would think that if they would just be happy to get any kind of verdict out of these jurors at this point, but we'll see how far the judge wants to push them on all of that. What do you think leads to these I know that you were reading tea leaves and I'm asking you to just kind of speculate, but what leads to these kinds of breakdowns in the jury room? And in this case in particular, they talked a lot about, it seemed like Weinstein's character was at issue. What do you think causes these breakdowns in jury rooms?
Josh, I think when you're dealing with these types of issues, right, that are highly contentious, it could be immigration, it can be race, and in this case, Me Too, right? I mean, Harvey Weinstein started the whole movement. There are people who think that Me Too has gone too far, and there are people that are bringing fake or non-meritorious allegations because if they were, why didn't you raise them years ago? Again, not saying I believe it, but there are people who have very strong feelings on these issues. I mean, we talked about the majority female jurors. A lot of female jurors, especially older, more conservative ones, would ask themselves, hey, I would never put myself in this situation and go up to some man's hotel room. What do you think is going to happen? And of course, there are people on the other side that say, you know what, women have been victimized by rich and powerful, famous men for years, and they're finally getting the justice that they deserve. So you're bringing in all those emotions and feelings, right? Jurors are ordinary people. They're supposed to decide the case solely based on the facts and evidence in the case, but you can't help sort of compartmentalize all that. That's why in these types of cases where sexual assault is one of the most underreported crimes, but of course it can also be falsely reported, and some of these victims have filed civil lawsuits. It is difficult to get 12 out of 12 unanimous New Yorkers to agree on anything, especially a case like this.
Yeah. Of course, whenever there's a conviction, it's amazing to me how quickly everyone's attention turns to the question of an appeal. Is he going to appeal? Is there anything to appeal? I'm curious about this issue with the arguments amongst the jurors. If some of this is true, if it sounds like what the foreperson was telling the court is that there was an understanding that some of the jurors might have been considering some things not in evidence, things like who Harvey Weinstein is, things that they shouldn't consider. Do you think his team is doing their best at this point to try to put together an appeal based on that? And then while you're answering that, consider also the idea that this is a split verdict. It does seem to show that the jurors were very conscientious in arriving at their decision.
Josh, I think that's absolutely right. And obviously you and I were prosecutors. And when we would get those guilty verdicts, we would talk to the jurors afterwards and we would cringe because I'm like, please do not say anything that is going to give these defense lawyers a reason to appeal, right? Don't talk about, Googling about the case or reading about it on social media or something completely inappropriate that was specified in the jury instructions that you're not supposed to consider, right? Because good defense lawyers are not just focused on the trial, they're also focused on the appeal. And this is a case where they've won on appeal. So you get one of those jurors to submit a declaration saying, hey, we were considering X, Y, and Z that we weren't supposed to. This was discussed. Guess what? You have a pretty good argument on appeal. So when I got those guilty verdicts, I just hope the jurors would go away, not talk to anyone, don't say anything. But to the extent that they're already saying they're considering who he is, not what he did, that's a problem for prosecutors in this case.
Yeah, major problem. I was the same way. If I would go out into the hallway after a guilty verdict and I saw defense counsel standing there talking to the jurors, and heaven forbid with a notebook out taking notes, I thought, oh God, here we go. And I'd rush over there and make sure that nothing awful was being said to blow up the entire case. But we will see what comes of this. It certainly with the defense team that he has and the resources that he has, I imagine they're going to leave no stone unturned.
What does retirement look like? To me, probably what you're dreaming of. A carefree, fun retirement with no worry that I have enough money. I mean, right? That's what we worry about when it comes to retirement. Will we have enough money? Well, today's podcast is sponsored by Acorns. Acorns is a financial wellness app that makes it easy to start investing for your retirement because the sooner you start, the more of a chance your money has to grow. You don't need to be an expert. Acorns recommends a diversified IRA portfolio that can help you weather all of the market's ups and downs. You don't need to be rich. Acorns lets you get started with the money that you've got right now. You'd be surprised at what just $5 a day could do. Plus, sign up for Acorns Gold and you'll get a 3% IRA match on new contributions in your first year. That's extra money for your retirement on Acorns. Investing can seem overwhelming or complicated, but Acorns makes it easy. Even if you start small, Acorns can help you get a plan in place to set yourself up for the future. Sign up now and join the over 1 million all-time customers who have already saved and invested over $2.2 billion for their retirement with Acorns. Head to acorns.com/truecrime or download the Acorns app to get started. Paid non-client endorsement compensation provides incentive to positively promote Acorns. Tier 1 compensation provided. Investing involves risk. Acorns Advisors, LLC, an SEC registered investment advisor. View important disclosures at acorns.com/truecrime.
Let's turn to Dedham, Massachusetts, where the battle of the experts continues in Karen Read's retrial as their defense calls what could be their last witness. Both sides have presented copious testimony from various reconstruction experts who attempted to recreate the conditions under which John O'Keefe died. Prosecutors came to the conclusion that Read maliciously struck the man with her SUV before leaving him to die in the snow, while her defense maintains that she never hit O'Keefe at all, claiming he was killed in the home of another officer and later moved. Testifying for the defense, Dr. Elizabeth LaPosada took this to the stand to offer her expert opinion on O'Keefe's injuries. She claimed that a skull fracture sustained to the back of O'Keefe's head was his likely cause of death, opining that the injury was likely caused by a rigid surface which didn't match the environment where O'Keefe's body was found. LaPosada contended that she didn't believe O'Keefe was struck by a vehicle at all, in a contentious cross-examination with prosecutors who called her credibility into question. Another expert, Andrew Rentschler, is testifying as we're recording this, and he is expected to be the defense's final witness. As this case draws near its conclusion, we will continue to keep you updated until we have a verdict. Neama, this case is interesting for a lot of different reasons, but we also have the benefit of this being a retrial and getting to see a change in strategy between how the prosecutors put on the first case and the second case and the defense, how they put on their case in the first case and the second case. Let's first talk about the prosecutors. Do you think that their kind of trimmed down approach benefited them this time around?
I do, Josh. And, retrials do generally favor the prosecution. The defense no longer has the element of surprise. Prosecution can get out bad facts, prepare their witnesses better. And in this particular case, we know that Michael Proctor was one of the worst witnesses that I've ever seen, probably since Mark Furman in the OJ case. We're talking about horrible, offensive, unprofessional things he did. The investigation was botched. Look, I give credit to the defense team. I know you know them. They're based out of LA. They did an outstanding job in the first case as well as the second one. And I know the Free Karen Read fans who are watching aren't going to hate this. I don't believe the Alpert conspiracy theory, but I also believe the Commonwealth may have overcharged this case. I don't think they have the evidence for second-degree murder necessarily. It seems like more of a typical vehicular manslaughter case. But I do think the new prosecutor in this case has done a better job. I don't know if they can get a guilty verdict. Still a tough case. But the fact that they focused this case on Karen Read's own words, they got Proctor out. I was wondering if the defense was going to call him. I mean, some of his terrible statements did come in through a supervisor, and they focused more on the science. I thought it was a much more effective presentation. And let's not forget, during the first trial, how the defense just pulled the jurors, we'd probably have acquittals on the most serious charges. So the defense did win the first time. We'll see if they have the same result this time around.
Excellent points. The defense also changed strategy to some extent, too, as you kind of alluded to there. One of the parts that seemed like it was hardest for jurors to wrap their heads around was this idea of a conspiracy and all of the people that would have to be involved in this cover up and framing of Karen Read. Not saying that they completely ditched that idea, but they did seem to focus less on that conspiracy concept and more on the idea of the state simply cannot prove that John O'Keefe was hit by a vehicle, according to their experts. Do you think that that was a smart strategic move and made for a stronger defense case as well this second time around?
I do, Josh, because look, it's reasonable doubt. We talked about Weinstein. You have to get 12 out of 12. And, you have a lot of conflicting evidence, right? We've spoken about that tail light, right? When was it damaged? Was it damaged when Karen Reed hit John O'Keefe? Was it damaged during a previous accident with his car? Was it damaged when the vehicle was impounded and towed through a blizzard, right? We've seen a lot of discussion about the head injury that O'Keefe suffered, right? The abrasions on his arm, those cuts. And now you have these experts, right? We talked about the forensic pathologist. The defense is ending right now with their biomechanical expert, who probably is going to be their best expert. We know it doesn't matter if you're the prosecution or defense, you always want to finish strong. So I think sometimes it's the availability of the witness, but to the extent that you have a choice, you're going to put your best witness last. And we'll see what the state does on rebuttal. Commonwealth, I know they said they might have a couple witnesses, but I think the safe course of action for a case like this, where you have this expert witness testimony, is just go for reasonable doubt, right? Because we know how high of a standard it is. You got to get those unanimous jurors, 12, all of them, without any holdouts. So I think that's a easier mountain to climb or hill to climb than to prove this conspiracy, right? No one in the Alpert's home, right, has come out and supported their theory of what happened. And I think, given the expert witness testimony that they have, I think it's easier to go that direction than to affirmatively prove something that may be somewhat of a conspiracy theory.
Excellent points again. I want to talk about, you mentioned experts a few times, and you hear many people referring to this case as now becoming a battle of the experts. And it kind of makes sense. The prosecution has called a few experts to say one thing. Defense is now well into their case, and they've called a few experts. But do you feel that the experts are the most important witnesses or evidence in this case, or is it something else?
Maybe it's just my skepticism as a lawyer and having hired many experts. You'll find an expert to say whatever you want, if you look far enough. And I'm not saying that they're lying. It's just they're in the business of providing testimony. So if I'm a juror, I look at the independent evidence, right? I look at Karen Reed's own statements, right, on Dateline saying that she hit him. I look at all the alcohol she consumed. Admittingly, she was a 0.09, I believe, at 6 a.m. or 7 a.m. the next day. So that's pretty significant. So at a minimum, I see someone who is significantly under the influence, right? Someone that, if you believe, you believe the surveillance video and the timeline of everything was driving under the influence of alcohol, it's very possible and believable and reasonably believable, in my opinion, that she struck him. So I would sort of exclude all this expert witness testimony because you're right. It's very conflicting. You have the pathologist that's saying there's no way that he was struck by a vehicle, that he lost consciousness inside the home, that he didn't die of hypothermia. He died inside the home and was frozen in the blizzard. So it's just so off, so completely different from what the state's neurosurgeon testified to, the ME testified to. If I'm not a scientist in this case and I hear that, I just set that aside. I ask myself, what can I see with my own eyes? And those videos are very important.
I think you're right. I think too much importance is placed on experts as if jurors cannot think for themselves and need to have this, need to be told what to think about the evidence and have it spoon fed to them. I think that for the most part, experts help them understand perhaps things that are a little too technical for them, but I don't know if they actually replace their own feelings about the case. At least that's my experience with dealing with experts, and I agree with you. You can find yourself an expert if you look long and hard enough and have a big enough wallet to basically say anything you want. Which brings me to my point of if I'm the defense, however, all I want them talking about is the experts, because I feel like there is a lot of confusion there and room for reasonable doubt. If I'm the prosecution, I probably don't want them thinking much about the experts at all. I want them thinking about a debris field of taillight fragments. And I want them thinking about her saying to people, I hit him. And all these other things that you just pointed out. If you're the prosecutor, I want you to kind of wear both hats now. Tell us what you're focusing on in closing as the prosecutor and the defense, because if last time around is any indication, they're not going to get much time. So they really have to narrow down what they argue to jurors at the end here.
I think that's absolutely right, Josh. If I'm the Commonwealth in this case, I focus on all the video evidence, right? I focus on Karen Reed's interviews, what she said, her admissions of drinking. You just go to that bar. She's taken shot after shot, doubles, and she's not, I mean, I know she's from Boston and they can drink in Boston, but she's still a petite woman, and I focus on, her behavior. And because if you're the prosecution, you want to be on offense, right? You don't want to be explaining away the botched prosecution. You don't want to be explaining away different expert testimony. You want to be aggressively going after Karen Reed, focusing on her words, focusing on her actions. Obviously, if you're the defense, you're going to take a very different position and say, listen, we have all these experts, all these scientists that point to this alternate theory. And ladies and gentlemen, if you don't know, that's reasonable doubt. And so I would absolutely go into that expert witness minefield if I were the defense. Have the jurors focus their attention on that. Was it really a broken glass and a broken taillight? If they start talking about, the timing that John O'Keefe's iPhone locked, when did it lock? Was that the last action on his phone? What about the Google search, how long to die in the cold? If you start going down that path, because there's significant disagreements as to causation, as to timing of everything, I think it's going to be very hard for the prosecution to get all 12 if the jurors are focused on that.
Yeah, I agree with you. I think that we will see that happen in closing arguments, which could be happening as early as this week. In fact, by the time we're releasing this podcast, they could be in the middle of them, or it could already be handed to the jurors, because it does seem like this is rapidly coming to its end, and we will continue to keep our eyes on it. Let's turn to our final case out of New York. A former girlfriend of the accused took the stand this week in the federal racketeering trial against Sean Diddy Combs. Identified only as Jane, the accuser recounted her chaotic romance with Combs from 2021 to 24 and described the relationship's descent into abuse, intimidation, and control. Jane testified that she was, quote, hooked from the beginning without understanding the terms and conditions of Combs' manipulation. Much of Jane's testimony echoed claims made by Cassie Ventura, also a longtime partner of Combs, in a lawsuit that proved to be the tip of the iceberg for Diddy's legal troubles. Under cross-examination, however, Jane was grilled about her continued relationship with Combs despite the man's alleged abuse, a tactic that has been used heavily by Combs' defense when confronting the accusers. While no cameras were allowed in the tense courtroom, we will continue to deliver you updates on Combs' case as it proceeds. Neama, I want to get into the federal stuff, and that's one of the reasons why I'm enjoying talking to you today about this case, with your background as a former AUSA. But let's first talk about this defense strategy on cross-examination with every single one of these victim witnesses. They have really highlighted the idea that they continued their relationship. They even exchanged kind words, text messages, emails, planned events with Combs, including these freak-offs, during and after the alleged abuse. Do you think that is effective?
I think it is effective. I'm not sure it will be enough. And it's interesting. The defense strategy here is they're cross-examining all these female victims with younger female lawyers. And I'm not saying Tenny Garagos is not qualified, but you have Mark Ignifilo, Brian Steele, a couple of the most experienced criminal defense trial lawyers in the country, right? Diddy has assembled his own version of the dream team, but there's a reason for this, because obviously you don't want an overbearing older male cross-examining a female victim. But I think you're right. And the defense strategy is twofold. The first is obviously they're arguing consent, but they're arguing this very interesting fetish. And it just came out during Jane's testimony. And I call it the cuckold defense. I can't take credit. Some of the reporters in the courtroom were texting me this. And that's that Diddy has this fetish where he likes to watch his partner have sex with other men. And these women, whether it's Cassie, whether it's Jane or whoever, they voluntarily agreed to it In Jane's case, it seemed like it was part of some sort of love contract where she was getting $10,000 a month for her rent. Cassie did it because she loved Diddy. And obviously we know that adults can consent to sex no matter how freaky it is. Now, I think the challenge the defense is going to have there is the physical violence. But to the extent the prosecution is relying on emotional coercion or financial coercion, I think that's a tougher hill to climb. You really want to focus on that physical violence, that force prong of sex trafficking rather than coercion.
It's such a nuanced subject and you handle it so well. But this idea of consent means a little bit more than disgust or reluctance or later on regret. I mean, it's this idea of somebody doing something against their will, not doing it, agreeing to do it, but not liking it. And I think that's what they've been able to highlight is that in some of these cases, it may seem that at worst, these people just really did not like it and did not enjoy it and may have been disgusted by it, but were perhaps agreeing to do it. Which brings me to my next point. If all of that is true, and again, I'm not saying it's true, and I don't want people coming after us in the comments saying that we're somehow condoning this. Neither one of us are. But how does that play into then the idea of sex trafficking and specifically racketeering? Because we've heard so much in this case about the RICO law and how are the feds going to put that together? Do you see issues in this case relating to that?
And I'm with you, Josh. I believe the victims. I'm a current plaintiff's lawyer. But look, I agree with you. There's vulnerability there, right? Sex trafficking requires force, fraud, or coercion. Has the government proven it? I think so, but maybe the jurors disagree. But that's why the RICO charge is so important, because even if the jurors believe this wasn't rape, but regret, right? This wasn't coercion. It was consensual. You can get to RICO through other ways. Obviously, sex trafficking is a RICO predicate act, but so is drug trafficking. So is prostitution. So is bribery. So is obstruction of justice. So is witness intimidation. So is arson, right? So you can prove these other RICO acts. If I'm the government, I argue, listen, this was sex trafficking. You should believe Jane. You should believe Mia. You should believe Cassie. You should believe Capricorn Clark. You should believe all the victims. But even if you don't, even if you believe the sexual activity was consensual, there's all this other criminal activity that they can't explain away. And under racketeering, of course, you need a criminal enterprise, but it doesn't have to be the mob or the cartel. We know that it can be Bad Boy Records with Combs calling the shots, right? And he has a bunch of people working for him that are getting him the drugs, that are hiring the sex workers, right? And then you need, obviously, the conspiracy, and then you need the pattern of racketeering activity. So it can be sex trafficking, but it could be some other racketeering activity. And I think the government's done a good job of proving everything else.
I'm glad to hear you say that, because many people are really kind of beating the drum that they have not proven it. And you, coming from your experience as a prosecutor, I don't want to put words in your mouth, but I'm getting from what you're arguing is that they have done a good job of that. Do you feel, though, that this case is kind of pushing that envelope a little bit about what a RICO case means? Because what we do believe a RICO case to be, for the most part, is dealing with things like the mob. It doesn't have to be. It's not in the statute. But traditionally, we think of things like more like what we would imagine when you say the words criminal organization, an organization that's looking to increase its power, increase money, whatever that is, for some sort of mission statement of their overall criminal enterprise. Whereas here, you got kind of a guy who's an egomaniac and maybe a megalomaniac and a lot of power, and he likes to control women, and he likes to kind of serve his own sexual desires. And he's very, very jealous. But does that qualify for a criminal organization?
Look, it's not typically used, but we've seen the expansion of RICO recently. Why do prosecutors love it? It brings in a lot of people and a lot of evidence into the case, right? You can charge, and we have a lot of unindicted co-conspirators here, but you can really lean on and put pressure on people, because if people are setting up the hotel rooms for the freak-offs and they're cleaning them up afterwards, they're criminally liable for sex trafficking, even if they didn't participate in the sex act. So prosecutors love it. Obviously, we saw it used in the R. Kelly case. We saw him in the NXIVM sex cult case. We even saw Donald Trump charged with RICO down in Fulton County. So people are very critical of it. I was charged in the Young Thug case that, look, RICO is being used in cases that it's not meant to be used for. So criminal defense lawyers hate it, just like they dislike 404B evidence, because again, it seems to be overbroad and not intended for this purpose in some cases. Look, in a clean case, this would be charged in LA County State Court with a 273.5 domestic violence, 261 rape. But we know the statute of limitations is run, and it's just not a state case. And you don't typically have domestic violence and rape in federal cases, right? You need those interstate components. That's why you got sex trafficking. But sex trafficking isn't human trafficking. Doesn't mean you got to throw someone in the back of a van and lock them up in a cage, right? Or pimp them out. It just, there has to be an interstate component. There has to be a commercial element. But really, it's that force, that coercion in a sex act, and that's sex trafficking. So some of this is fitting a square peg into a round hole a bit. But if you really go through those jury instructions, and obviously you and I know them, but I think members of the public don't, you will see, and those jurors will see that if you just look at the instructions, Combs fits into the definition of RICO. He fits into the definition of sex trafficking. And they've certainly proven the Mann Act, the prostitution charges. So I think that's a given at this point.
Neama, it's always a fascinating conversation when we have you on. I thank you so much. I learned so much hearing you walk through these things. Tell people where they can find out more about you.
So I'm at Neama Rahmani on all social media platforms. That's Neama Rahmani. My firm is West Coast Trial Lawyers on the same. Thanks for having me, Josh. It's always good to see you.
Absolutely. And I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can check out my brand new YouTube channel, Courtroom Confidential. And you can, as always, find our Sidebar episodes wherever you get your podcasts. And we would love to hear from you. If you've got questions or comments you'd like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.